Joanne, of course, has appeared in a string of recent cases at the highest level, including acting for the successful appellant in the Supreme Court in the case of S. Francis against the Cavendish Hotel, which is the leading case on Ground F redevelopment. And she was also recently in the Court of Appeal case of Churston Golf Club, and she has twice, 2 years on the trot, run Real Estate Silk of the Year. So Joanne really needs no introduction. Emer is no stranger at all to high-profile property litigation. She's appeared against Joanne, in fact, in one of the most prestigious property cases of recent years, which was the so-called Brexit case, you'll all remember, of Canary Wharf and the European Medicines Agency. That was last year. And one client was recently quoted as saying of Emer that she is simply the best junior we've used. You can't have a more ringing endorsement than that. So we are in for a very interesting afternoon discussing the case of Duval, where they obviously acted together. Before I ask Emer to give us a quick snapshot of Duval, just one item of housekeeping for you all. We're using a version of Zoom today that enables you to ask or to send in questions as you go along. So down on the sort of toolbar at the bottom of your screens, you should find a Q&A button. That will bring up a separate window, and you are very welcome to type questions into that. And we will do our best to field those questions at an appropriate moment during the course of the webinar. Okay, Emer.
Thanks, Julian, for that very over-the-top introduction. Right, to give a snapshot of the Supreme Court's decision, it's all about leases that have a landlord covenant to enforce covenants in other leases. And in those cases, in a nutshell, landlords are limited in their ability to license departures from lessees' covenants in a way that is new and different to what people had understood in the past.
Yeah, so I think many of you will be familiar with the background. I know that a lot of people on this call will probably have followed the decision as it moved up through the Court of Appeal to the Supreme Court. But just by way of background for those who aren't that familiar with it. So we're dealing with a building in Maida Vale. It was previously 2 mid-terraced houses, and they'd been converted into 9 flats, once part of the Church Commissioners' Maida Vale estate. And in the 1980s, the Church Commissioners had sold off the estate, and each block had been transferred, the freehold of each block had been transferred to a company owned by all the lessees in the block. And just to get a little bit boring, I need to show you a couple of slides just to outline the key lease covenants that were in issue. So I'm going to try and share my screen. Let's do that. Now I'm hoping that you'll be able then to see the key provisions. There are 3 of them really. So clause 2.6 was a tenant's covenant, not without the previous written consent of the landlord, to erect any structure, pipe, partition, wire or post upon the demised premises, or make or suffer to be made any alteration or improvement in or addition to the demised premises. So a covenant against works, but importantly, a qualified covenant, that these things could be done with the previous written consent of the landlord. Then, sorry, I wasn't doing that properly, was I? Clause 2.7 was an absolute covenant, not to commit waste, spoil or destruction in or upon the demised premises, nor cut, maim or injure any roof, wall or ceiling within or enclosing the demised premises, or any sewers, drains, pipes, etc. And the significant thing about this is it also prohibited certain kinds of works, but it's an absolute covenant, no provision in it for the landlord to give consent. And lastly, for these purposes, clause 319, which was the critically important clause, in 2 parts. The first part of the clause is a landlord's covenant that every lease in a residential unit would contain covenants of a similar nature. And the second part of this was a landlord's covenant that at the request of the tenant and subject to payment by the tenant of and provision beforehand of security for the costs of the landlord. So 2 important conditions. The tenant has to make a request and has to provide beforehand security costs to the landlord. The landlord would enforce any covenants entered into by tenants of other residential units of a similar nature to those contained in clause 2. So they were the critically important lease provisions.
I think I can jump in here just to explain a bit about the facts, which are actually very straightforward. Mrs. Winfield, who was the lessee of one flat in the block, wanted to carry out works which would involve removing part of a load-bearing wall in her flat. This was prohibited by clause 2.7, so that's the absolute covenant against cutting or maiming roofs, walls, ceilings, etc. She applied for a licence from the landlord, and the landlord was minded to grant the licence, but another tenant, Dr. Duval, contended that to do so would breach a covenant in her lease, i.e. clause 3.19, by which the landlord promised to enforce covenants in all the other tenants' leases. And so battle lines were drawn, and the question for the court was whether granting a licence to Mrs. Winfield would breach obligations to Dr. Duval and, in brackets, to all of the other tenants in the block.
Okay, and so, I mean, how common are these sorts of covenants? I mean, I think we've all seen in certain residential leases that you do get covenants of this type, but presumably in researching the case, you had to sort of look more widely. I mean, how often does this sort of issue arise in practice?
They're really very, very frequent. So essentially there are three kind of enforcement models for covenants. There's the sort of commercial model whereby the landlord takes covenant from each lessee and doesn't make any promises about what to do with them, and it retains complete control over whether or not it enforces against breaches of those covenants. At the other extreme, there's a letting scheme where you can have every lessee is entitled to enforce directly the leases, the covenants and the leases of all other people in the scheme. Quite complex, a number of problems associated with letting schemes, so they're not very common. And the sort of model that we have here sits in the middle of those two extremes. So as we've seen, it's got the landlord covenanting that it will enforce the covenants of other leases. And we did a bit of research when we were applying for permission to appeal to the Supreme Court to try and ascertain how common these were. And they do seem to be very, very widespread. So we found that these kind of provisions are contained in a number of precedents that are still in precedent banks, and have been for a long time. So if you went back into the 1980s, you could also find precedents containing these kind of covenants, and they're still being used today. And also we did a bit of sampling across what had been the Church Commissioners Maid of Vale estate. So we knew this one building was part of that estate, about 2,000 properties in that estate, and it was apparent that we were dealing with a standard form of lease. So it's not, I can't say what percentage of residential flats flat leases will contain provisions like this, but I can say they're really, really commonplace.
I'm going to take a question now from Tristan Ward, who's got a question here about clause 3.19. And Tristan asks, what difference would it have made to the case had the leases not contained a covenant to grant other leases in substantially the same form? Now, I mean, I suppose that might arguably have the potential to affect which category of case of the three groupings that you've indicated that a case might fall into. I mean, what would the difference have been, do you believe?
I think that's a really interesting question. Thank you for that, Tristan. It's not something we really explored because these particular leases have both provisions. But the really critical part of clause 319 for the Supreme Court's analysis is the second part, the promise to enforce the covenants in other leases. So my thinking would be that actually it wouldn't matter if the landlord hadn't given the first part of the covenant.
Yeah, I think that's right, Joanne. I mean, the term that the Supreme Court actually implied was a promise by the landlord not to put it out of its power to enforce, in this case, clause 2.7, in the leases of other lessees by licensing what would be a breach of clause 2.7. And the crux of the decision was that the purpose of that second bit, well, the whole purpose of both bits of 3.19, but in particular, the second bit, this promise to enforce covenants and other tenants' leases, was to provide protection to tenants. And they said, if you apply Marks and Spencer, the test for implied terms, there would be no practical content to that promise if the landlord could vary or modify or authorise breaches from that covenant. And it seems to me that even without the first part of 3.19, which was the bit about similar granting leases on similar terms, if you had this promise to enforce covenants and other tenants' leases, then on the Supreme Court's reasoning, that is a promise that is given to protect the tenant. And on their reasoning, there would be no practical content in that promise if the landlord was able to vary or release or modify other tenants' covenants. So actually, I agree with Joanne. I don't think it would make much difference. I suppose the only caveat I would put in is that it might be more unusual to have that set up where you wouldn't have the leases all in a similar form, but you would still have a promise to enforce. I'm sure it exists, but it seemed to us that it was more common to have either in fact or in law, all the leases being the same or similar, and then this promise to enforce them all, because there's obviously a reciprocity going on there.
Because it would follow from what you're saying that in theory you could have a property divided into, let's say, 6 leases, and one of those leases contained a unique absolute covenant, and the basic principle that the Supreme Court have held here would still apply, even though none of the other tenants actually owe that obligation.
Yeah.
Because it's not really the reciprocity of obligations that's the key point. The key point is that the landlord has given a promise to the person in Dr. Duval's position. And let's say there was a good reason for having a unique covenant. For example, it was a basement flat and, you know, particular works couldn't be done because it was a basement flat, or it was a flat that includes the roof or something like that. So there might be good reasons why in practice only one lessee had given that particular covenant, but the critical question is, does the landlord have a free hand to release or modify it without reference to those that it's given the covenant like 319 to?
Yeah, and a unique covenant like that can just as easily be for the protection of the building as a whole, if it's don't dig through the foundations or don't do something to the roof or whatever it may be.
Yeah.
I mean, the way the Supreme Court decided it was all based on an implied term, wasn't it? I mean, how did the Supreme Court approach the implication?
Well, as you said, it was actually very narrow. They recognised a term on the Marks and Spencer's test. So in every case, every lease will have to be looked at and it will have to strictly pass that test in order for this implied term to be recognised. But as far as we can see, it's very difficult to see why that same reasoning wouldn't apply in almost all leases where a landlord has given this landlord enforcement covenant. The only thing that we can imagine, I mean, it's, you know, there's no doubt millions of different types of leases, and it's dangerous, I suppose, to guess in advance. But the only thing we think would make a difference would be express wording recognising the landlord's freedom of action. So saying something like, nothing in this lease prevents the landlord from permitting breaches or licensing departures from covenants or something like that, which would negate the implied term. But notwithstanding the narrow way that the judgment is framed, it seems to us to have pretty wide implication. Actually, we had some questions about this before the seminar. So I think Janice Northover asked, would the outcome of the case have been the same if clause 3.19 didn't include the second part? I think we've probably answered that already with addressing the question that came in from Tristan. As we've said, it's the second part, this landlord promise to enforce, that was the crucial part of 3.19, more so than the first part of 3.19, which was about granting leases on similar terms.
Yeah.
And we also had another question from Guy Joseph, who asked, if there were leases in different terms, could the freeholder relax a clause in one lease and not others? And actually, I think we've probably covered that as well. If the implied covenant sort of sits with and arises as a result of this second part of 3.19. So if you've got that second part of 3.19, our view is this implied term is very likely to arise, notwithstanding the differences between all the leases to which it applies.
Okay, we've got another question that's come in on the live feed from Shula Rich, which has a bearing on this. So Shula asks, do you think it would make a difference if the landlord's clause also allowed the landlord some latitude, even when indemnified. In other words, the landlord could consider enforcement to be, in quotes, the interest of good estates management, and she says that she frequently finds that in leaseholders' arrangements in Brighton. What's the thinking there?
I would think that that might well be a significant difference in particular cases. So that kind of clause gives the landlord a bit more scope. It leaves more of the decision about whether or not to enforce against a breach with the landlord. Having said that, I don't think myself, I'd be interested to see what Emer thinks. I don't think the landlord could think that there wasn't an implied term at all. It's still going to be constrained by the fact that it has given a covenant to lessee A that it will do something as against lessee B. So you might end up with a different fact pattern. You might find that the landlord hasn't breached the implied term, but I think there still would be one.
Yeah, I think there would still be some limits on the freedom of what the landlord is able to do, because they'd have to show that licensing the breach was in the interest of good estate management or something along those lines. They couldn't just say that they didn't really see any problem with it, so that was fine. It could, and there would obviously be cases when, notwithstanding the fact that the license is being granted to one tenant, it could well be in the interest of good estate management, because it means everyone is content with what's going on in their flats, and their freedom of action is recognised, and value is recognised in their flats. But there would be other cases where they'd say, well, we just don't see any benefit for this for the wider community, so we can't justify it, even though we've got no particular problem with it. So I agree with Joanne, there would still be limits. I think the implied term in that case would probably be somewhat more nuanced, though.
Okay, thank you to Sheila for that question. I mean, obviously in the background here were these two specific covenants in this lease, clause 2.6 and clause 2.7, and the Supreme Court approached that element of the case in a different way to the way in which the Court of Appeal had. I mean, what was the Supreme Court's approach, and why did they reach those conclusions?
Yeah, it was interesting, really, because there'd been consensus between the parties and, in fact, all the lower courts all the way up the court structure, that the absolute covenant in 2.7 effectively set the boundaries for clause 2.6, the qualified covenant, so that you had to read the two together. And since there was an absolute prohibition on certain types of works, if your works fell within that clause, then they couldn't fall within clause 2.6. And that had the consequence that the implied term would capture all sorts of things that lessees would consider completely normal in their residential flats. You know, sort of putting a new kitchen in, or a new extractor fan. And remember, these are leases of 125 years. How many times are you going to have to replace your kitchen or bathroom in that time? And as I said to the Supreme Court, you know, that 1980s avocado bathroom suite is not still going to be around in 99 or 100 years' time. And actually, the Supreme Court reversed that, you know, sort of departed from the consensus of the parties, which was reflected in the Court of Appeal's judgment, and said, no, you have to read clause 2.6 much more broadly, and that basically anything that would be a kind of routine alteration that a lessee would expect to carry out to their flat must fall within 2.6, and the landlord can give permission for that. And it's only really, you know, quite extreme or structural works that fall within 2.7. Now, obviously, that's a good result, I think, for tenants and landlords, because it does give a broad power to landlords to license in appropriate circumstances, to license routine works. I just have to say, personally, I can't get there on the words. I can't get there on the words used of those clauses. It's a really, really purposive sort of approach.
Did you, again, in preparing for the case, did you form the view that this particular combination of provisions is quite common in residential leases, or is it a bit of a one-off?
I don't think it's a one-off at all, but I think probably unlike clause 3.19, there are more subtle nuances in the drafting of particular leases. So exactly where the line, I mean, it's not uncommon, and I'm sure there'll be people in the meeting who have a view on this. It's not uncommon to have two covenants, one an absolute one, often related to structural work, and a qualified one relating to non-structural work. But exactly where the boundary of those two comes is going to vary from lease to lease, I think.
And the oddity here was that the absolute covenant was framed in much wider terms, wasn't it, at least arguably, and I suppose that was the view that had been taken below. We've got another question from Tristan Ward that has a bearing, he raised a question about this, and the question is, was there any discussion as to whether clause 2.6 was wholly a qualified covenant or partly qualified and partly absolute?
No, there wasn't any discussion about that. I think there was an agreement that 2.6 on its terms was a wholly qualified covenant, in the sense that the landlord could give consent to the works which fell within the terms of that covenant. Obviously, importantly, it's got to be seen against the background of section 19 of the Landlord and Tenant Act 1927, which imposes a limitation that a landlord mustn't act unreasonably when deciding to withhold consent to improvements.
Okay.
So that's an important constraint on that clause.
Then we've got another question from Sarah Ferguson about this. The qualified covenants, about the interrelationship between the two. The qualified covenant and the absolute covenant seem to overlap in terms of the works that they cover. But was it the case that the qualified covenant only relates to the part actually demised, which didn't include the structure? And then the follow-up is, why wasn't the absolute covenant read subject to the qualified covenant, which seemed to be wide enough to permit the works that were proposed?
Do you want to go for that, Emer, or?
Yeah, so the way that it worked in this case was the demise was quite specific. So it actually only demised the internal parts of the flat. Any load-bearing walls at all were excluded. And so there were these sort of floating bits of freehold in the middle of these leases, or in the middle of these flats, sorry, which the landlord retained possession of. And the absolute covenant was clear that it applied to any works to the demise or anything within the demise, including bits that were still in possession of the landlord. And so removing the load-bearing walls was actually removing part of the landlord's property, and thus 2.7 applied. There wasn't a way to shoehorn it into 2.6, because notwithstanding, even if 2.6, even if you read it in the really purposive way that the Supreme Court did, you have to then also recognise that what was happening was removal of part of the landlord's property. So it was always going to be a problem. That being said, the Supreme Court found their way around it. So, that was one of the reasons why we, I think, were quite surprised by the way that they had interpreted 2.6 and 2.7, because 2.7 did have this broad impact. And it was a really purposive reading of 2.6 to allow certain routine works, notwithstanding the fact that 2.7 had recognised that it applied this absolute covenant to both to the demise, but also any property within the demise, such as property still in the possession of the landlord.
It does highlight the importance, obviously we see it a lot in our work, but of knowing exactly what the extent of the demise is, because that's likely to be a critical point of distinction between qualified covenants and absolute covenants. It's much less likely that a landlord will have taken only a qualified covenant in relation to something that it has retained within its own possession.
Okay, well, we're getting quite a few questions on the covenants, but I'm going to suggest that we move on to just think a bit more about the pragmatics and the practical implications, and we can always come back to some of these questions at the end. I mean, what does all this mean in practice for landlords of, the sort of residential block that was being considered in Duval?
Well, the Supreme Court took the same approach as the Court of Appeal, and they said the landlord is able to grant a licence to the Mrs. Winfields of the world. It has the power to do that, but in doing that, it puts itself in breach of this implied term in all the other leases in the block. And so the landlord in this case, had it proceeded with the licence, would have been at risk a claim by all the other tenants in the block. And that would be the same, we think, in any other case where this kind of implied term is recognised. The only way around it is to get a positive agreement of all the other tenants in the block to this work that's going to breach the absolute covenant, which obviously creates a whole host of problems. Even in Randolph Crescent, there are only 9 flats, or a small number of flats, so it's definitely on the easier end of the scale. But you have to get a positive response from everybody. Even just getting 9 or 10 leaseholders to respond to a request like this is difficult, never mind trying to get them all to agree to it. So very difficult for landlords who will be asked to grant licenses and having to say no a lot, and difficult for tenants who might want to do works that previously they had understood they would be able to do, or had just assumed that they'd be able to do. Having paid over £1 million for a flat, you might think you're able to do what you want. But the result of the Supreme Court case is that actually their freedom of action is similarly more limited, because they can't just get consent from the landlord if they're able to show that there's no issue with the works. They have to get the consent positively from all other tenants.
And are we, I mean, again, important and fairly obvious question, are we dealing here purely with covenants against alterations and improvements, or does this apply to all covenants, all absolute covenants in lease?
Yeah, it's all covenants, and I think that's the thing that doesn't perhaps jump out at you from the Supreme Court's decision, because the way they formulate the implied term is by reference to works. And because of course the particular covenant in issue here, clause 2.7, was a covenant relating to works. But the rationale of the Supreme Court's decision clearly applies to every covenant, because the second part of clause 3.19 is not confined to enforcing covenants about alterations or about works. It is about every covenant of a similar nature in other leases. So, you know, there are a number of different possibilities. There may be covenants against, you know, which would prevent people having lodgers, covenants that may prevent people having pets, covenants requiring flats to be carpeted. Even one of the examples in this particular lease was a covenant about the payment of interest at a particular rate on service charges. The landlord can't even grant a waiver of that without breaching its implied term.
I mean, this is all making it sound pretty tricky for landlords going forward after this decision. And I'm reminded that the Court of Appeal took the view that actually the risk to many landlords was going to be pretty theoretical, that often enough, I think Lord Justice Lewison said, you know, an application would be made, no other tenant in the block would know, the landlord could give license to it, and by the time many other tenants found out, there wouldn't be much of a remedy to be obtained in a cause of action for breach by the landlord. I mean, where does the Supreme Court decision leave that, and what do you think of the reasoning in the Court of Appeal on that point?
Well, personally, I think the concept which underpinned the Court of Appeal's discussion, that effectively the landlord can deal with this in secret, is pretty unrealistic. I mean, some people are going to get to know, aren't they, about what's going on in their building. If you've got a structure like we had here, where the landlord is a company owned by all of the lessees, then there's going to be information coming out about that company. And it does seem quite in conflict with the sort of policy of openness that you would expect in terms of good estate management, and you know, certainly in the context of collective enfranchisement and that sort of thing, where you would expect landlords to have open policies about how they might deal with licenses for works or licenses for other things. The idea that the landlord might sort of do a side deal with somebody and not tell the others doesn't sit very well with me, I have to say.
Yeah, and I agree. And I think the other assumption that was made by Mr. Justice Lewison, that you wouldn't get an injunction in most cases and you wouldn't get substantial damages. I'm not saying that they're definitely wrong, those assumptions, but I think they're questionable in some cases. if you go along asking for an interim injunction, you're likely to get one, because on American animated principles, there's a serious issue to be tried, and you want to keep the status quo pending trial. If you establish prior to the works being done that the landlord, in granting a license, is proposing to act in breach of a proposing to act in breach of a negative covenant, i.e. not to put it out of its power to enforce covenants if requested, the risk of getting a final injunction, I don't think that's negligible at all. And then the damages question is very, very tricky. We've had a couple of questions about this from people before the seminar started, or before the webinar started, sorry. People have asked, well, what about negotiating damages? Couldn't the tenant say, well, you have to pay me the amount that I would have charged you to release my veto, over anything that departs from the covenants in the other tenants' leases. And we did look into this a bit before the Supreme Court. We thought it was possible, given the way that the case law on release fee negotiating damages has gone recently, that could well be a case where you get negotiating damages, which would obviously be very significant. And there'd also be, if a tenant could establish some loss, they would also have the ability to claim damages to reflect that loss if there was any loss to their own flat. But it's more difficult. We feel that there were other remedies better targeted to loss to a tenant's premises, that they wouldn't necessarily need to rely on this implied term. They could just sue in nuisance or sue for trespass or whatever, depending on the facts. And the other factor as well is that even if Mr. Justice Lewison is right, and actually, although there's a theoretical breach of this implied term, there's no remedy for the tenants. What about the legal costs? Who's going to pay those? It's we will all as practitioners on the webinar will be very familiar with neighbourhood disputes getting entirely out of hand and people getting very vindictive and immense legal costs being racked up. Somebody's going to have to pay them. And if the landlord is acting in breach, if it's the one in breach, then it's got to be at substantial risk of having to pay the costs of the whole thing. So it's very difficult, we think, to be too dismissive about the likely remedies. Not to overstate it, obviously there will be lots of cases where the tenant can't prove any loss, but there will definitely be cases we feel where it's not going to be as clear cut as Mr. Justice Lewison seemed to assume.
And it's in a very potentially litigious context, isn't it? Because so many of these sorts of disputes are ultimately just neighbour disputes, and we all know that those can be the most bitter and intractable of all. So that doesn't bode well, does it? Let's have a look at some of the questions that have come in. So Danielle Drummond-Brassington has asked a question on remedies. If a landlord did license works that would otherwise be a breach of an absolute covenant, how would damages be assessed for breach of the mutual enforcement covenant? And was there any discussion of this before the Supreme Court? I think that's what you've just been addressing. So was it dealt with by the Supreme Court at all, that question?
It's not addressed in their judgment, but we did deal with that in our written case. Thank you, Danny. And you and I have discussed negotiating damages and release fee damages in this context before. So that was an argument that we put forward against the proposition from the Court of Appeal that it wouldn't be problematic in practice, but it's not addressed at all in the judgment. I think Simon Francis also asked a question along similar lines. So hi, Simon.
Just looking down here to see whether we've got any more points on remedies. Well, so David Honeyman has asked, again, you may have covered some of this, what remedies does the successful party have? Is the appellant in this case entitled to damages or specific performance? And if the latter, would there be any time limits?
I think we'd call it injunction rather than specific performance, but you're right, an equitable response to actually prevent a licence being granted is definitely a prospect, and that is in fact the remedy that was sought and originally granted by the Deputy District Judge in the Duval case. So there are time limits, not strict time limits about injunction, but it's being an equitable remedy. You'll lose the opportunity to get an injunction if you hang around too long. The question is, what does too long mean? And there are interesting questions, I think, as well, very interesting questions about can a licence once granted be reversed? I think that's a really interesting case there to be litigated by any of the property litigators out there, but certainly there are cases around assignments in breach of covenant, and where the court has held that the assignment can be reversed because the assignee knew that the assignment was in breach of covenant. And, you know, scope for similar sort of reasoning here, perhaps, that the license can be reversed because the licensee, who obviously is likely to occupy under a license which itself contains an enforcement covenant, is likely to know that that's a breach of covenant by the landlord.
Yeah, we had a couple of questions before the session started on that. So Matthew Melling asked whether a license could be voided if it was granted in breach of covenant, and you've as you just said, that's an interesting question for the future. And Leonore Santville asks, can landlords require the requesting tenant to give an indemnity?
Yeah, I mean, that seems to me to be a really important way forward for landlords who are inclined to grant a license, would be to seek an indemnity from the tenant asking for the license. Obviously, that's quite a potentially big burden on the requesting tenant, you know, with the risk of a damages claim against the landlord coming home to roost and all the costs associated with that coming home to roost on them. There's also the issue that it transfers the credit risk to the landlord. What happens if the indemnifying tenant isn't good for the money? What happens if they move out or if they become difficult to trace? So yes, an important potential way forward in some cases, but it's going to need to be carefully considered, I'd have thought. Okay,
and I mean, one feature of the case, which is a common feature with many of these sorts of multi-occupied residential leasehold buildings, is that the landlord was a company owned collectively by the tenants. Did that have any bearing on the Supreme Court's decision? Should it have had any bearing?
Well, I can take this one. It didn't make any difference in the Supreme Court's reasoning in the end. The reasoning applies whether the landlord is one entity or whether it's owned by, whether it's a company or not, whether it's owned by the tenants or not. The same reasoning will apply. We had argued that because in our case, the lessees had rights because they had shares in the landlord, the tenants and the landlord were all one and the same. The landlord was the company that was owned by the tenants. We said that that was the way that the parties had anticipated each other individual tenants having an element of control over what the landlord licensed or didn't license in breach of absolute covenants. That didn't feature in the Supreme Court's reasoning. They obviously decided that they didn't like that argument. Whether it should have done that, that's obviously what we argued. There's also, to be fair, you could say, well, it's a bit of a artificial distinction in lots of cases as to whether the company is owned by the tenants or whether it's not. And there might be cases where the company is owned by the tenants, but the leases make no reference to that and they hadn't anticipated that, so why should that make any difference? But in the end of the day, the Supreme Court has decided that no, it doesn't make any difference.
And what about where landlords have previously granted licenses like the one here? They may have done that in the past, and now this decision has been handed down. I mean, are those landlords now potentially going to find themselves being sued for past breaches?
Okay, so there is a risk. The limitation period for an action for breach of covenant, and that would include the breach of the implied term, is 12 years. So there's potentially a long tail of liability for landlords. And because the nature of our law is that the Supreme Court declares what the law has always been, it's no defence for a landlord to say, well, I didn't know about the Duval case at the time I granted the licence. Having said that, one has to be realistic about how likely any objecting tenant would be to get any kind of effective remedy if the works have been carried out and been completed and no complaint had been made. As we discussed earlier, the prospect of an injunction recedes with time, and if the objecting tenant can't show any actual loss to itself, I'd have thought the court's probably going to give short shrift to any claim. It's just the uncertainty, really, isn't it? It's it's the risk factor that you might perhaps get a nuisance claim.
I mean, our colleague Jonathan Chu has asked whether estoppel might have a role. Are there any escape routes for landlords in this situation? Might the tenant be stopped from complaining given they knew of the works, but then he makes the point reliance would be difficult? I suppose it's all ultimately pretty fact sensitive, isn't it? It
is pretty fact sensitive, and I suppose if you're really running an estoppel case, you'd need to show that that the objecting tenant had led the landlord to believe that it wouldn't complain, and probably picking over the facts in most cases you won't get there, particularly just if there's silence, if they just haven't complained in the past, or they've complained about the works but haven't taken the point that it's a breach of covenant on the part of the landlord, then that's not going to be sufficient for an estoppel.
No, I agree.
And then we've got a related question. Edward Burton's case is the question is related to this. He asks, what's the position of the tenant who's had works licensed by a landlord which would have breached the terms of the lease, i.e. because it contravened an absolute covenant, which have now been completed? Practically hard to see an issue, but he says this actually happens in many London estates regularly in Edward's experience.
Yeah, that's right. I mean, one of the, in terms of the practicalities, I think it is, as I've just said, that the risk to a landlord are probably quite small if the works have been completed, even if the landlord was in breach at the time. But one thing to bear in mind is that the reasoning of the Supreme Court would apply not just to absolute covenants, but also to qualified covenants which haven't been strictly complied with. So clause 2.6 is very typical in that it says that the tenant must not do something without the prior written consent of the landlord, which means that the landlord can only give consent within the scope of that covenant in advance and in writing. Whereas if the works have been carried out without asking for consent, and the landlord is retrospectively asked to license those works, that will be a breach of the implied term. It's not just confined to absolute covenants.
Yeah, okay. Yeah. So that extends the scope of it quite considerably, doesn't it, potentially? Yeah, okay.
It does. It does, and obviously the sort of very common scenario of having a retrospective license for works granted just prior to a sale, when everyone realises, oh dear, some works were done and we probably should have asked the landlord about that. And the seller goes off and gets a retrospective license from the landlord and it's all sorted. That particular solution now looks to be problematic because actually the landlord can't just grant this retrospective license. Well, maybe it can, but in doing so, it potentially puts itself in breach of the implied term and all the other tenants' leases.
Yeah. Okay. So, I mean, I suppose all that begs the question: how should a landlord now approach the whole question of considering and granting licenses for works to be carried out in contravention of these sorts of covenant?
Carefully, I think, is the answer. One of the real difficulties for landlords is that if you're dealing with works, which are probably the most likely scenario in which a license is going to be requested, you've somehow got to disentangle from what might be a single scheme of works, those which fall within something like clause 2.6. and those which fall within something like clause 2.7. Because under clause 2.6, not only can the landlord give consent, by statute it mustn't unreasonably withhold consent. So it has to positively consider the rights and wrongs of giving consent in relation to works which fall within that qualified covenant. On the other hand, says the Supreme Court, it will put itself in breach of all the other leases if it grants consent for works which fall within 2.7 or its equivalent. So that's going to take a lot of very careful thought about exactly where the line is to be drawn. And as I said earlier, that may not be obvious. It may depend on the extent of the demise, may depend on the exact construction of the two clauses. So that's going to be quite interesting. That doesn't give you an answer, does it? What should landlords do? Clearly, one option is to do what the Supreme Court thinks ought to be done and go and seek the consent of all the other lessees in the flats, in the block. That's going to be difficult, if not impossible, with a block of any size, effectively. And the second thing to do is to do what the Court of Appeal suggested, which is to grant it secretly. And as we've said, we see problems with that in practice. It does require the landlord to take on risks. And the third option is just to say no if it falls within clause 2.7. No, and I personally think that's the most likely outcome for most landlords.
I mean, I do think one thing that landlords could do, which might assist, is I think they'd be justified in asking any scheme of works that's being put forward for it to be set out very clearly why the tenant says that this is covered by the qualified covenant and doesn't fall within the absolute covenant, to try and get the requesting tenant to do some of the homework on that, rather than sending off a scheme of works and saying, please give us consent. I think they're justified now in saying, well, look, we've got these two covenants. I can only grant consent if it falls within the first one. Can you please set out your reasoning why you say this scheme of works falls within the first and doesn't fall within the second? At least to give the landlord somewhere to start to see whether, well, yes, this, we can be confident this is within 2.6. Anyone who's saying it isn't is just causing trouble. But of course, we can all imagine many cases where it's just not clear. It's just not clear which side of a line the works fall within, and that's why licenses are often drafted in such a way that they are given under the qualified covenant, but they also say, and if these works breach any other covenant, then we're licensing it under those as well, or we're licensing a departure from those covenants too. It's just going to be very difficult for landlords.
I mean, what sort of drafting solutions are there to all of this for those who are fortunate enough to, I suppose, be embarking on the grant of these sorts of leases in the first place?
Well, that's probably easier, isn't it? I mean, it's always easier to draft things for the future that take into account a significant decision like this. So I would have thought the obvious things are to widen the scope of qualified covenants, so as to make clear that the landlord does, there's quite a big scope of a big ambit for the sort of covenants which give the landlord the ability to consent without infringing any other leases. Thinking hard about the extent of the demise, that's going to be important. And I would have thought there's scope for inserting an express provision giving the landlord, express provision in clause 319, in that equivalent, giving the landlord an express power to grant licenses, perhaps in certain circumstances. Yeah. Because obviously if you've got an express term, then that's going to override the implied term that the Supreme Court's found.
Yeah.
Okay, let's have a look. We've got a large number of questions coming. I don't think we're going to be able to answer them all, but let's have a look at some of them. So Emma Butcher has asked, do you think the decision would have been any similar application to a lease where there is an express covenant to the landlord to enforce covenants against other tenants, but it's the landlord which is acting in breach of the covenants in relation to retained parts or units in a new development which have not yet been sold?
That's very interesting, Emma. I would have thought, although the Supreme Court's decision is about what the landlord can do vis-a-vis other tenants, a landlord which is itself doing what it's promised other tenants won't do must be in breach of a provision in the lease, I would have thought. What do you think, Emer?
Yeah, it's difficult. It is difficult. I mean, I think where there is an express covenant to enforce against the other tenants, but there aren't any other tenants yet. There is a lease, but it's not owned by anyone apart from the landlord. You can't sue yourself, and you can't be, you can't be in breach to an obligation to yourself. So to that extent, as long as the lease hasn't actually been granted to anybody, or if it is, it's not anybody separate, then I think the landlord should be safe enough. But once it's sold, then I think you're going to have a problem. Going to have a problem going forward.
I think it's a really interesting question, Emma. Thank you for that. And I don't think the Duval Supreme Court decision is going to give us the answer to that. That's like the next stage, isn't it? The next round of potential litigation about the extent to which there would be an implied obligation on the landlord where it's still retaining the flats itself.
Yeah, we've got another question here from an anonymous attendee who hasn't wanted to give their name. Would there be a difference if the lease had both this clause and constituted a letting scheme? So if the lessee did receive consent from the landlord, but there was still a cause of action directly from another tenant?
I think the presence of this clause prevents there being a letting scheme, or is a strong sign that there is not a letting scheme, because if you've got a letting scheme, the concept is that it's not the landlord enforcing on behalf of other tenants, which is the essence of the second part of clause 319. The concept is that all the tenants can go directly against one another.
I think that's right. But one thing that we had in our researches for the Supreme Court, where there is a letting scheme, the landlord isn't free to grant licenses like this. That's one of the implications of having a letting scheme, is that the landlord's freedom of action is already limited. They can't just go granting licenses in breach of or in departures from covenants in the leases, because other tenants have this power that they can go off and enforce the covenants themselves. So it would conflict with that power if the landlord was able to override it. So I think in letting schemes, the restriction already applies, if that makes sense. The landlord doesn't have the power already.
Okay, let's have a look at some others here. I'm just going to start plucking these fairly at random. Jonathan Channing asks, absolute covenants often apply to pretty straightforward flooring alterations, carpets to hard flooring, originally drafted for good reason due to noise penetration. If blocks of flats want to allow acoustically tested hard flooring and restrictive covenants exist, is the only legally safe option to vary all the leases?
I think it may well be. I mean, that example of a covenant requiring carpets was one that was discussed before the Supreme Court, and we made the point that that's the sort of thing which you might expect particularly over 125 years to want to change. But I think you're right, Jonathan, that if the landlord is not prepared to take the risks that we've discussed, then the way forward is to vary all the leases. But that's a big job, isn't it? And that certainly requires the positive consent of all the lessees in the building.
And then we've got a question from Keith Conway. Is there a case for law reform?
Keith, since you're on the PLA Law Reform Committee, I believe, there's certainly a case for law reform.
Yeah, I mean, it's interesting, isn't it? Because on the one hand, practically speaking, practitioners look at this and think this just causes so many problems for landlords trying to manage buildings. But on the other hand, what the Supreme Court seemed to be very keen to recognise was that if you've given every tenant this promise that you will enforce covenants in every other lease, then that is something they should be able to rely upon. And if you are able to go and vary the other tenants' leases somewhat behind their back, then that's a promise without content. That's the way that the Supreme Court looked at it. And that in itself is supposed to be a recognition of the power that is given to a tenant when they take this lease. And now I think it might have some perverse consequences in terms of the limits on what tenants are able to do with their flats as a consequence of this. But I think that the way the Supreme Court's the sort of nub of their case, or the nub of their reasoning, was to say this is giving tenants power. The tenants have taken a lease, they've paid valuable money for this lease, and it says that they can make the landlord enforce the clauses in all the tenants' covenants, and we're not going to let that be cut down. And you know, in a way, they're trying to recognise tenant power. So I wonder whether, you know, from a practitioner point of view, we can see all sorts of problems with this, but from a sort of law reform point of view, some people might think that that's the right way to go, that tenant power should be what you recognise.
It's clearly, it's a policy decision. I mean, in the right way, it's a legal policy decision about where do you find the balance between a tenant who wants to do something which departs from their lease and the other lessees in the block, and there are legitimate concerns of both. And, you know, where does the law draw the line? So it's certainly an area in which you could see there might be interest in law reform, but it's actually quite difficult to know what an Act of Parliament would say as to where you draw that balance.
Mm-hmm. Okay. Question from Caroline Ciel. What about statutory lease extensions? Could this prevent landlords seeking to update or modernise leases? Landlords frequently try to introduce new terms, arguing that the changes are permitted under the 1993 Act.
I wouldn't have thought it would prevent the landlords trying to update or modernise leases. I would have thought almost on the contrary, that you might see arguments in response to this decision saying, well, now we recognise the limitations on the landlord as a consequence of this lease we've got. We need to develop the drafting so that it's more flexible.
I agree.
Okay.
I agree.
And then we've still got time for one or two more. Jason Hunter asks, in light of Duval, what would you advise a conveyancer acting for a buyer proposed mortgagee of a flat which has been extended into the roof space / roof, perhaps some years ago? Should they counsel their clients not to proceed?
Probably not. You're talking about, Jason, you're talking about something that's happened some years ago. Remember that the Supreme Court has confirmed, as the Court of Appeal did, that the licence, I'm assuming your question involves a licence, the licence is effective. So as between the tenant who's done the works and the landlord who's granted the licence, that licence is effective and means the tenant can't be sued anymore by the landlord. The question raised by the Duval case is the landlord then liable to another lessee or more than one lessee in the same block? So the risks to the tenant who's been granted a licence are actually smaller than the risks to the landlord. We talked earlier about the potential for a reversal, but that would be a mandatory injunction reversing a licence, which if the works have taken place some time ago probably wouldn't be granted.
No, I think if my own view would, I completely agree with what Joanne said. The risk for a tenant, apart from the very theoretical risk of a mandatory injunction, which, as Joanne said, is unlikely to be granted in relation to works from some time ago, would be that if there's a kind of Duval structure where the tenant also becomes a shareholder in the landlord, then that is where the risk then, they might have a potential risk as a shareholder of the landlord, and the landlord's potentially liable. So it's back into the questions of these tail end liabilities for things that happened in the past. And as we've said, you know, we don't want to overstate the risks to landlords from these tail end liabilities. And I think it will just have to be a case of the tenant taking a common sense view of thinking, well, if no one's complained about it for the past 10 years, is anyone going to complain about it now in a way that's going to result in either substantial damages or substantial legal fees? And take a view on that. I think it would be pretty extreme to say don't go ahead at all because of this risk, because in somewhere like London, for example, this problem's going to come up time and again, and people just don't have the ability to go and get another property at the drop of a hat, and they might decide it's worth the small tail risk that might come with it.
What I would say to your competitor, sorry, I think there's maybe a bit of an echo on my mic, is that the thing that the conveyancer doesn't want to advise, I think, is go and ask the landlord now for a retrospective licence, because in a way that's stirring up a problem now. It may be better to let sleeping dogs lie, as it were.
Yeah.
Okay, look, let's just take one more. There's still a lot of questions and you've generated a lot of interest with this decision and discussion, but we're not going to be able to get through them all. So an anonymous attendee asks, how influential do you think this decision will be in relation to a freehold development with a management company retaining control of the common parts and the building scheme in place? Will the position be different if the development is a mix of leasehold, freehold properties, all bound by the same restrictive covenants and managed by the same management company?
For myself, I see the critical part of the Supreme Court's decision coming back to almost where we started, as being that second part of clause 319. If that covenant has been given to anybody on the estate, then the landlord is potentially exposed to risks by granting licenses. Now, where it will fall as between the freeholders and the leaseholders will depend on the scope of that promise to enforce covenants. But if the landlord has positively promised anybody that it's going to enforce, for example, the restrictive covenants in freehold properties, then it is potentially at risk if it doesn't have an expressibility to waive breaches.
Yeah, I think that's right. I think that's right. That must be right, because it all flows from that promise to enforce. If the landlord has given, or the freeholder, whomever, or the company has given this promise to enforce, then all other things being equal, the Supreme Court's decision says you have also implicitly promised not to put out of your power the ability to enforce. So you can't go granting licenses without the consent of all the other people involved.
Okay, probably a good place to stop, because I think that underlines one of the themes that to me has certainly come over from many of your answers, which is the width of applicability of this judgment, actually, and it has quite a significant impact across quite a lot of areas of property law. So, and I'm sure that's why so many people joined us. So I think it just remains for me to say thank you very much to Joanne and Emer for their very stimulating discussion, and actually it's tribute to the discussion that we've had so many questions in. I'm sorry we couldn't answer everybody's questions. Thank you for joining us. I'm sure Joanne and Emer are happy to try and follow up with questions afterwards if you want to carry on the discussion offline or by email or whatever it may be. And we very much look forward to seeing you all at the next Wilberforce Hot Topic webinar to be announced, whenever that will be. Okay. Thank you very much. Stay safe and well. Take care.
Thank you very much. Nice to be here.
Thank you all.